Hi, this is John Goodman. I promise that I will make this relevant to real estate in just a minute. But first, let me start with an analogy. Suppose you're buying a used car from a car dealership. This dealership offers a certified pre-owned warranty for this vehicle. The warranty says, we're warranting this vehicle that it's perfect. It's perfect for a finite amount of time, subject to an exception. Now, there's one style of exception that could be an exception that's very broad, it's very general. For example, the exception could be for any problems that could have been discovered at the time of the sale. I'll call that a general exception to the warranty. Let's contrast that with an exception to the warranty that said, we're warranting that it's perfect except for the power windows and the sunroof. Well, which exception is better for the buyer? The second exception is better for the buyer. The itemized exception, the car-specific exception is better for the buyer because it's narrower, it's itemized. The general exception, the exception to the warranty for anything that could have been discovered at the time of the sale of the car is better for the seller because it's broader. It's not as good for the buyer. All right, let's try and make that analogy relevant for real estate. Imagine you are a property owner and you are selling a property in the year that this video is being recorded, 2018. Imagine you actually go under contract to sell it to a buyer for $500,000. $500,000. However, once the transaction goes under contract, the part of the due diligence is you provide a title commitment to the buyer, and it's discovered that there is an easement that is burdening your property that inhibits a buyer from building a house in the ideal location to take advantage of the terrain of the property and the views of the property. And so because this buyer cannot build their house where they would like to, that first buyer terminates the contract, and now you have to go out and now you have to go out and sell the property, find another buyer who is willing to buy this property subject to this easement that burdens the property. Eventually, you are able to find a buyer, but because this property has this title blemish, this easement that encumbers, that interferes with people's ability to build their house where they would like to, you are now only able to sell the property to the market for $400,000. So you, as the seller, are damaged by $100,000, the difference between the value of the property unencumbered by this easement and the value of the property encumbered by this easement. So let's say this easement was a surprise to you. You had no knowledge of it. It was something that was created before you acquired title to the property. It's also not something that was revealed to you when you purchased the property. It was not shown as an exception to the title insurance policy that you got when you purchased the property. So what are your options now? You have $100,000 of damages. Well, generally, your quickest path to cash is to file a claim with your title company. And this is the type of claim where if the title company simply missed an easement that existed that encumbered this property before you acquired title to it, this is the kind of claim that a title company is generally pretty good about paying the claim quickly. So great news, you get your $100,000 claim paid, unless you don't have $100,000 of coverage in your policy. And why might you have less than $100,000 of coverage in this for this property? Because you purchased the property 50 years ago, and when you purchased this plot of land for $40,000, you only got $40,000 of title insurance. The title company on your title policy, assuming there's no inflation endorsement, will be happy to pay you $40,000, but that will not cover all of your $100,000 loss. You still have $60,000 of loss. Might you be able to recover against the seller for that $60,000 loss? Well, let's assume that the deed that you received was a general warranty deed. And a general warranty deed, it's a little bit of an oversimplification, but the general warranty deeds is the seller saying, we're warranting perfect title to your property. But then it follows with an except Now, there's two styles of exceptions to the general warranty in the general warranty deed. One type of exception is an exception that said that's a general exception to the warranty of title in a general warranty deed, a generic exception that might say all reservations, rights of way, and restrictions of record. Well, since that easement was of record at the time you acquired the property 40, 50 years ago, you would not have recourse against your seller in that situation. Suppose instead the general warranty deed that you received 40 or 50 years ago when you acquired the property said, we're warranting perfect title to your property except for these two things, whatever those two things are. And the easement that we're talking about, the surprise easement, is not one of the things listed on the exception. With that kind of exception, the itemized exception, the narrow exceptions, the property-specific exceptions, as contrasted with the generic exception, the buyer would have a claim against the seller because this easement is not specifically accepted from the general warranty of title that the seller granted you a long time ago. So, narrow itemized exceptions to warranties are better for buyers. General exceptions are better for sellers. Now, the drafters of contracts, or at least the drafters of the Colorado Real Estate Commission approved contract form, had a decision to make. Are sellers obligated to convey deeds, general warranty deeds, that narrowly accept out title to the property, narrowly set out exceptions to the general warranty, a deed that's better for the buyer, or may sellers convey a general warranty deed that has a general generic exception for all reservations, rights of way, and restrictions of record? And the drafters of the Colorado Real Estate Commission approved contract have pretty clearly provided that the deed be more buyer oriented. It have property specific exceptions rather than generic exceptions. And yet, title companies in Colorado routinely prepare deeds. The generic deeds that come out of their deed creation systems have the generic general exception rather than the limited property specific exception. Why do title companies prepare deeds that seem to be inconsistent with the contract? And the answer is that if the title company narrowly lists out all the exceptions of the property, essentially the title company is revealing the fruits of its intellectual property, its title searching services, that allows subsequent title companies to sort of get a free ride right on the coattails of the list of title blemishes that the original title company has produced. So title companies generally do not produce deeds with itemized property-specific exceptions. The Division of Real Estate in its 2018 update class is trying to make the point on brokers, hey brokers, you're responsible that these deeds are prepared consistently with the contract. You're responsible for educating the title company to prepare the deeds correctly. This used to be a big deal issue to me. When I was a young lawyer, the contracts called for a deed with a buyer's oriented itemized exception, itemized list of exceptions, and title companies weren't preparing things correctly. And I was, Paul Revere, instead of saying the British are coming, I was Paul Revere saying these deeds need to be prepared correctly, and they're not being prepared correctly. I was a young lawyer then. I was interested in making the world a better place. I am not so focused on this issue anymore. And it's not just because I'm jaded and cynical, although I am a little bit jaded and cynical. The reason is 30 years into the practice of law, I've never actually seen a title claim turn on this issue or not. In order for this, and I think I know why, in order for this issue to come up, two things have to be true. One of them is that the title company 40 or 50 years ago has to have missed the title blemish. Does that happen? Yes. It doesn't happen very often, but it happens. But there's another thing that has to happen in order for this difference in deeds to make a difference. And the other thing that has to happen in order for this difference in different styles and deeds to make a difference is the person who's making the title claim has to have title insurance that's capped at an amount that's inadequate to cover the claim. The reason that happened in this story is the sellers of this property, the damaged party in this property, bought the property 40, 50 years ago. It can happen for other reasons. For example, it can happen for builders. A builder might buy a lot for $40,000, build a $500,000 house on it, sell it to the market, have a title blemish that causes damages of $100,000, but only has a title policy that's capped at 40. It can happen. Those two things can coincide. The mistake, the title searching mistake, and inadequate insurance, I haven't seen it happen. Now, when I'm a lawyer representing a buyer, I have the clout, I have the sophistication, I have the contract language to insist on an itemized list of exceptions that are specific to this particular property. The Division of Real Estate is suggesting that it's incumbent on brokers to do the same thing. Of course, if your regulator thinks you should do it, I think you should do it too. So, mind this issue. Mind this issue. All right, that's it for this presentation. Remember, it's a complicated world. Be careful out there.